Council, members of the jury. First thing I want to do is thank you for your patience and your service and your sacrifice. This service, as all jury service, is obviously a sacrifice. You're torn from your families and your work. You have to come down to court. But in this case, it's been even a greater sacrifice because you've been sequestered because of the type of case this is. You've been away from your families at nighttime too. And we thank you for that because we can make you come down here and you can get on the jury. But we can't make you pay attention to the evidence. But you've all been very attentive. You've all been very patient. You've listened to the evidence because you know how important this case is. I want to talk to you about some of the things we talked about in jury selection. One of the things obviously is central to this case is the law of self-defense, and we talked about that. Self-defense is a law most jurors understand because it's what I call a natural defense. People understand it. But in this case, the definitions you get is would a reasonable person use deadly force? A reasonable person can use deadly force. An individual can use that deadly force under the circumstances if they believe it's immediately necessary. And we talk about, and you'll get a definition of what reasonableness is, an ordinary prudent person under the circumstances, in the same circumstances as the defendant. That's how you have to look at it. And we went over that carefully with you during jury selections, that in this case, when you review the evidence, decisions made by Amber Guyger, you have to view it from all the facts surrounding the case and under her circumstances, from her viewpoint. We also talked about the concept of apparent danger, whereas there can be the defendant can have a belief, a reasonable belief, and believe deadly force is about to be used, but it turns out the threat's not real. Because you can't always make that decision. The decision to use deadly force can be made in a second that decides life or death. And the law allows someone that if a reasonable person in that position to believe their life is in danger, they can exercise it. And the court is clear and has included those instructions to you. And you'll have them back there that you can go over. But I want to emphasize this to you. When a person is attacked by an unlawful deadly force, or she reasonably believes she is under attack or attempted attack by unlawful deadly force, one or more persons, and there is created in the mind of such a person a reasonable expectation of fear of death or serious bodily injury to herself at the hands of such attacker or attackers, then the law excuses or justifies such a person resorting to deadly force by any means at her command to the degree she reasonably believes it may be necessary. Viewed from the standpoint at that time to protect herself from such an attack. In considering such circumstances, you should place yourself in the defendant's position at the time and view them from her standpoint alone. Because the law recognizes that mistakes can be made. It's always tragic. The law is not perfect. It's tragic. But you have to follow this law. We went over this in jury selection. I wanted to make sure that everyone could follow it. Jurors that couldn't aren't on this jury. 16, you said you could. And recognize how this situation might happen. We hear about these incidents sometimes that are so tragic. A student may come home to surprise her parents, comes in the house from a college weekend. They don't know what's happening. A father could kill a daughter. All these are horrible, tragic things that happen. But that doesn't make them criminally responsible given those particular fact situations. We also talked about, and I think this is most important, the state's burden of proof. It's beyond a reasonable doubt. You as jurors have heard it when you grew up, I'm sure, in school, what beyond a reasonable doubt is. It is the highest burden under our law. You don't get a definition, but the court would tell you it's the highest burden under the law. And we talked about what is probable cause. It's arresting someone. When you sue someone for millions of dollars, it's preponderance of the evidence is the burden. When the state wants to take children from a parent's custody, it's clear and convincing evidence. But to convict someone of any criminal offense and murder, it's beyond a reasonable doubt. The highest burden under the law. That burden is on them and it never shifts. the defense has no burden to prove. And when self-defense is raised under the law, the state of Texas must prove beyond a reasonable doubt the defendant wasn't acting in self-defense. That's the law. When self-defense is raised, when that evidence is raised, the state of Texas must prove to you beyond a reasonable doubt the defendant wasn't acting in self-defense. And if they can't do that, it's not guilty. Same thing on mistake of fact. If they can't prove the defendant wasn't operating under mistake of fact beyond a reasonable doubt, the instructions are clear, it's a not guilty. That is the law. And your oath in this case is to make your decision on the law and evidence. And it's clear. And here's what we're talking about, reasonable doubt. I put this up during jury selection. I want to remind you, just to illustrate how high that burden is. Low, obviously proven not guilty. Highly unlikely. If the evidence shows it's less than likely. Probably not. Unlikely. Possibly not. Clearly, that's not guilty. If the evidence shows it may not be, or perhaps that happened, or suspected the defendant committed murder. Possibly guilty. Probably guilty. Guilty likely. Guilty highly likely. Still doesn't reach that burden of beyond a reasonable doubt that you're required when considering these issues in this case. Don't forget that. It's a cornerstone of our Constitution that separates us from all of the countries in the world. And you've promised and taken an oath that you'll abide by that. When we talk about beyond a reasonable doubt, it's talking about it's a doubt based on reason, using logic. And what the state has to do, and that burden never shares it, is rule out every logical possible reasonable doubt. And they can't do that in this case. They can't do that in self-defense issues. They can't do that on the mistake of fact issues. I also asked you in jury selection to do this, and it's so hard, it's human nature to keep your mind open throughout the whole trial, to wait till all the evidence is in, and then review the court's charge, the law, and apply it to the case. It's very hard to do because in human nature, we want to start making decisions right away. We get angry, we get emotional when we hear evidence, and you want to start forming your opinions. But you have to use the discipline not to do that. And you all promised you could do that. The other thing you have to be careful of, and there's an instruction on that in here, is that you don't, as the jurors in this case, decide this case on emotion and sympathy. That's hard. Especially in a case like this. You'll never see a case like this. It's so tragic. So tragic. It's hard to do as jurors. Who would not have sympathy for Bob and John? Wonderful human being. Died in these horrible, tragic circumstances. Who would not have sympathy for his family? Or anyone in that position? Everyone does. But that is not part of your consideration as a jury. You can't say, I feel so horrible, I'm going to make something happen. That's hard to do. You have to calmly review the evidence without that emotion. And follow your oaths. They don't want you to do that. They want you to be angry and upset. Because that's what they need to do, because they can't get over this burden of proof beyond a reasonable doubt otherwise. They want you charged up. Now, I'll ask you to follow the law, because if we have jurors who are deciding things on emotion, then bad things can happen in criminal cases, and that's why the law is so clear. And you all promised that you could do that, and you could use that self-discipline. And we want you, we believe you. We want you to adhere to that promise. Here's the other thing. This case is different because there's been so much publicity. We had specific questions about it. Everyone's heard about it. It's been covered and covered and covered in the press, on social media. But all of you said, yes, if you heard about it, you put those things out of your mind and recognize the importance of deciding this case just on the evidence here in the courtroom. Because all that media coverage, everything you see on Facebook or any other social media, hasn't heard the actual evidence. You have. You're the only ones in the unique position to do that. The judges safeguarded this, made sure that jurors would be on the juror who had not formed opinions and could make these decisions. She sequestered you so you could avoid these pressures. And there is tremendous public pressure in a case like this. But I'll caution you, you as jurors have to ignore that, and that's very hard. Because people are upset about this case. It's emotionally charged. But if a jury starts making decisions because of public pressure, or, well, will they respond if I find this way? We can't get true justice in this country. Jurors must make their decision just based on the evidence and not how they think people want them to find. And I'll ask you to always have that in the forefront of your deliberations when you calmly and without emotion review this evidence. I want to talk about some other evidence. I had a slide up in jury selection about distraction. You need to concentrate on what the evidence is of what happened outside the apartment when Amber Guyger went in and what happened inside. What led up to it. Those are the circumstances. The circumstances viewed from Amber Guyger and the decision she made. That's what's important, because we heard all kinds of evidence about things that happened after the shooting happened. All kinds of evidence. That's a distraction, because it has nothing to do with the decisions were made in that apartment and just outside the apartment. Let me give you some examples. We heard about questions about should he use the walkie-talkie. She used a cell phone. Should have used a walkie-talkie. That's proper procedure. What does that have to do with beyond a reasonable doubt? Mistake of fact, reasonableness. What does that have to do? The incident happened. And when you look at the evidence, how quickly did an ambulance and officers get there? Within 2 minutes. Sergeant Valentine said she got there within 1 minute. What was the purpose of that? That's emotionally charging you up to get you angry. Oh, she didn't use her walkie-talkie. Is it their belief that Amber Guyger purposely wanted to slow down emergency personnel to get there? No. There was no undue delay, and it has nothing to do with what happened in that apartment, but it's a distraction. No CPR. We either had evidence of she didn't do CPR at all, didn't have blood on her hands. I'll remind you, though, that the other officers that did CPR didn't have blood on their hands. Or she can discontinue doing CPR too soon, or didn't do it properly. Okay? All kinds of good questions about you didn't do CPR like the other officers when he was in his last moments of his life. And that's very emotional. Because, yes, anyone laying there mortally wounded needs to be tended to. But what does that have to do with what happened in the apartment, or what you decide? Nothing. Nothing at all. It's designed to get you upset, to get you emotional. Amber Guyger said when she realized what was going on, she tried CPR with one hand. The operator, the 911 operator, wanted to know where she is. She doesn't know. She's realizing, come to the grip, she doesn't know where she is. She thought she had been in her apartment. She had to get up, go outside, and look. That's how confused she was at that point in time. And she told you, I did sternum rubs. Those weren't going to do him any good. But she wanted him to wake up. She'd seen paramedics do it. She was desperate. She wanted help to arrive. She left his side once to go outside because she'd been told by the 911 operator the officers were there. They're trying to find her. She wanted them to get help for him. She couldn't help him. And sadly, we now know from the medical examiner that bullet tore through his heart. CPR wasn't doing any good. Pressure on the wound wasn't doing any good because he had, the medical examiner called a rapidly fatal wound. He couldn't survive because of the wound he received. And CPR wasn't going to help. There's no one from Baylor Hospital that came in here and said, oh, if only CPR had been done continuously, he would survive. No, sadly, that's the hard truth. That's the hard truth. But we heard all kinds of evidence about it, questions, to get you emotionally charged up in your deliberations. We heard about texting, of course, horrible deed. About 3 minutes, 25 seconds into that 911 call, she sent 2 texts. Or one text about a minute later, 45 seconds, another, to Martin Rivera. She's in absolute panic. I don't think anyone can doubt that when you listen to that 911 report. And she wants that one person, her partner, that she depends on, there. She's just reaching out. Now, you can hate her for sending that text. You can. You can be angry with her. You can hate her, but you can't convict her because that's no evidence as to the decisions that were made in that apartment. It has nothing to do with it. But we heard all about it and took evidence because that, again, is designed to get you upset and angry. Because if you're angry at the defendant, it's much easier to convict them. But you have to look at this case coolly and calmly and decide if they've proven their case beyond a reasonable doubt. On this mistake of fact issue, on this apparent danger of what she was perceiving and going into that apartment thinking it was her own. It's a horrible, tragic event that happened from these mistakes and misperceptions that were made. The deleted text. You'll hear about that. Deleted text. Martin Rivera, yeah, I deleted text. Well, we all know why Martin Rivera deleted text. He's a married man. He had an affair. He was sending sexually explicit text messages and photos with Amber Guyger. He doesn't want his wife to find that out. Amber Guyger always deleted his messages until after this incident. Embarrassed, she said, also didn't want people to know, and she didn't want Martin Rivera to be in trouble. But does that have anything to do with what happened? No, not at all. Police procedures. All things about police procedures. And this is where they try to misconstrue what actually happened. Amber Guyger wasn't there to answer a police call, a burglary call. She wasn't called by a resident when she arrived and said, I think someone's breaking into an apartment, go there. They have procedures when they're called to those types of calls. That wasn't happening. She was just trying to go to her apartment. She wasn't there on a call. You heard Officer Blair when he talked about it. He said, yeah, sure, if I'm called to a burglary, I'm going to call for cover, get another officer if I'm called on a call like that. But if I'm going in my own home and I run into someone inside my home, I'm going to engage. I'm not going to retreat. I'm going to look for his hands. I'm going to face the situation. Amber Guyger wasn't there answering a burglary call. She didn't sit outside that apartment and heard rustling and said, well, it sounds like a burglar in my apartment. Should I call for cover or not? She explained to you exactly what happened. That decision happened in seconds and had nothing to do with any kind of burglary call. But we heard all about these procedures of calling for canine units, backup. It has nothing to do with the facts of this case. And then we heard about Martin Rivera. The theory was, you heard that he was supposed to come over and either Amber Guyger was so excited she made all these mistakes or she was so disappointed. That's pure conjecture. But they use an email or a text from Martin where he said around 5:55 p.m., when can I come over? And we know from what they both testified to that they sent these texts to each other all the time, but there was no plan for him to come over. They both told you that. Martin Rivera went to a Boy Scout meeting. Then he went to the gym, and then he stopped to get something to eat. And was his habit when he was out doing that, he would call Amber Guyger. And they told you that, yes, they'd had a sexual relationship, but that had ended either late 2017 or in early 2018. And Amber Guyger told you, and Martin Rivera told you, she'd lived in Southside Flats for 57 days, and he had not been over there. He didn't even know where she lived. How could he go over there? And we know they're telling the truth about that because this table, with their investigators, the Texas Rangers, their prosecutors, their technology, if they wanted to track Martin Rivera and prove that he lied, that he was always over at the Southside Flats, they could. They know what to do with cell phones, cell towers, videos, information from cars. But you didn't hear that because he's never been there, and he wasn't going there that night. Amber Guyger was just wanting to go home. Work out, take the next day off. Martin Rivera, he's going to work the next day. They weren't having a day. She wasn't distracted, where she made a series of horrible mistakes. What you have to look at in this case, and look at mistake of fact, because the evidence is clear on that in the law. A person's conduct that would otherwise constitute a crime of murder or manslaughter is not a criminal offense if the person, through mistake, formed a reasonable belief about a matter of fact, and the mistaken belief negated the kind of culpability required for commission of the offense. The defendant is not required to prove that she made a mistake of fact. Rather, the state must prove beyond a reasonable doubt that the defendant did not make a mistake of fact constituting a defense. And the judge carefully lays that out. They can never overcome that burden in this case if you follow the law and the evidence. Reasonable belief means a belief by an ordinary prudent person would have held under the same circumstances as the defendant. And to decide the issue of mistake of fact, you must determine whether the state has proved beyond a reasonable doubt one of the following. The defendant did not believe she was entering her own apartment, or did not believe that the deceased was an intruder in her apartment. Or the defendant's belief that she was entering her own apartment, or her belief that the deceased was an intruder in her apartment was not reasonable. So let's talk about reasonable. We know from looking at the photos that that garage was not clearly marked. We know that from Detective Clark, who gathered all the evidence and she was putting the photos in. She didn't even know the difference between the third and fourth floor. She said that on the stand. I can't tell the difference. There were no large markers until after this shooting occurred on there. Just small little markers of where the fourth floor would be on the inside of that elevator. They look just alike. People make that mistake all the time. We know that. We know that their own witnesses, Josh Brown, has gone to the wrong hallway and gone to the wrong apartment and put a key into it. But they did something else, because obviously Ranger Armstrong gets on the case the next day and he knows, hey, we need to figure out if that's reasonable. People actually do this. And so what did they do? They brought a bunch of Texas Rangers out, they brought investigators, and they canvassed that entire complex because they wanted to know if this had happened to anyone else. And you'll get the statistics, and he testified to them. Could have the next slide, please. I'm sorry, that's not it. When they questioned everyone, 93 people had said they'd gone to the wrong floor. And when they looked at it for the third and people that lived on the third and fourth floor, 46% of the tenants on the third and fourth floor had unintentionally parked on the wrong floor. 46%. Are those people unreasonable? When Amber Guyger is on the phone and parks on the wrong floor, what about all these other people? Nearly half, 44% of the tenants on the third and fourth floor said they unintentionally walked to the wrong apartment on the wrong floor. 44%, that's 92 people, said they'd done the same thing Amber Guyger had done. So when you're considering whether it's a reasonable mistake, consider that. As Ranger Armstrong said, he thought it was a very significant fact. They're the ones that found this evidence. Their lead investigator and the other Rangers, they found it. That's the evidence. What you consider, if this is reasonable mistake of what a person would do in this case. They can't hide from that fact. It's right there. They found it. What about their own witnesses? You know, we heard on opening statement, Mr. Hermes said Amber Guyger went past 16 apartments. She was on the wrong floor. She didn't see the roof line when she went across the bridge. She missed or didn't see mats that she should have been familiar with. She missed the big chromatic plant or whatever. Should have realized that. She made horrible mistakes. Yet it happens all the time. Whitney Hughes, a witness for them who lived across from Mr. Jean, said, yeah, I parked on the wrong garage twice. And I went with her down the hallways. I showed her, okay, there's a river rock mat. No, I missed that. She may have saw some other mats. Said, I'm not sure. As in regards to that plant, I saw that, but I thought maybe the neighbor put it out. People do that all the time. She went to her own, what she believed to be her own apartment. And her own apartment has a brown mat. This one doesn't, we can see in the video. And she put the key in. It wasn't until then that she looked up. Their own witnesses have made the same mistake. Josh Brown made that mistake. It happens all the time. We brought you other witnesses. Mr. Lipscomb, who went to the wrong floor and wrong apartment about a dozen times, he told you. He went once when he came out walking his dog and went in all the way in, saw a woman sitting on the couch and still didn't realize he was in the wrong apartment. We've heard evidence of doors not working properly, people not being able to find their friends there, the numbers being confused. They're up high, as Whitney Hughes said, up high, not on the door like you normally see. It's confusing, the very design. And now, finally, this evidence, the door being ajar, is so important when deciding the mistake of fact, the reasonableness of what Amber Guyger did. Because she told you, it's been her story, when she walked up to that door, the door was ajar. Now, this would be the view from the inside. The door was ajar. We know how the lock works. You have to put the key in. If it's shut, if it's not your key, a red light will go off. You have to turn it if a green light comes on, and then you have to turn the handle. That didn't happen in this case because the door was ajar. And how do we know she's telling the truth about that? Because Ranger Armstrong went on September 8th to video the inside of Mr. John's apartment, and he closed the door behind him. And then when they were video in the room, they eventually came to this. Now, you didn't see it when the state played it, but we played the rest of it. And we came to this. They saw that the door hadn't shut because there's a problem with the strike plate. It doesn't shut, and it didn't shut on that day. And they videotaped it and have it documented. So all you have to do when you put the fob in is it makes the door open. Not only that, they came back in October. Ranger Armstrong came back with people from the district attorney's office. They said it was the same time of night, the same weather conditions, and what did they find? His door didn't shut often. It was in the same condition Amber Guyger said that's how it was. All right? She's not lying about that. She's not lying at all. That's what happened in this case. It's one of the series of horrible circumstances that aligned together that resulted in this tragedy. All these other people have gone to the wrong apartment, put keys in. And that's what happened with Amber Guyger. She walked down that hallway just like all the others did, except she had something else different. She had about 30 pounds of equipment hanging on her left arm. She had this, walking on her left hand. Just wanted to go home, just calm, like the others, just like Whitney Hughes wanted to go home. And she didn't notice these things. And she comes up, and there's, you've seen in some of the photos, a pillar that sticks out as you're coming up. She knows her apartment because she doesn't look for the numbers, just like everyone else doesn't. They can sense where they are, and she knows that where that balcony is, that's where her apartment's going to be, 1378. And she comes up, she's getting her keys. She's coming up here to where this red mat would be. But she's got this. And it could easily obscure what she's doing, and she's not looking at the ground. And we know that 43 inches is how high it is, and she's 5'3" maybe. So she's not looking down here to put it in, it's here, right about here. And she's not thinking anything in particular at all, just has her equipment. And she described to you what happened. And it takes a long time, and they want you to think it happened a long time, but it didn't. It happens in seconds. And she told you how she went from complete calm to complete panic. And you've all experienced in your life. Thank God not in this kind of situation. Ranger Armstrong said, yes, it can happen. You get the tunnel vision. Your heart suddenly kicks in. Blood is rushing because suddenly you feel in danger. You may have experienced that when you're driving down the highway. When you wander another lane or someone wanders in your lane. Or some child runs out in front of you. You have to slam on the brakes. Calm 1 minute, you have to react. You have to avoid a collision. You have to avoid a child. And if you do so, what do you hear? That heart beating, sweat. It happens in a nanosecond. And that's what happened. And Amber Guyger explained to you what happened. She walks up. She doesn't wait outside or anything. She's putting the fob in. It's going in. Right at that second, she sees the door that's ajar. The very motion of that pulls the door open, and the very same time she hears rustling around. All those things come together. Her test tightens up, and she says, my God, someone's in my apartment, because she left it locked. Someone's in my apartment. And that door's opening up. She doesn't wait around at that point and decide to charge in. It's opening up all in one motion. This is all happening in 1 second or two. And she pulls that door open, and the lights are off, and she's face to face there at the end of the apartment with a figure. And her heart is beating, and she is scared. It's a reasonable mistake anyone could make. And her gun is pulled out, and she points it at the figure. And she tells you what she said. Training kicks in this. Let me see your hands. Let me see your hands. But he's moving around. That frightens her. He doesn't comply. In fact, he comes forward. He's walking. And he's saying, hey, hey, hey. All she's thinking in her mind is, ignore my gun. He must have something. He's coming to harm me. And she has to make that split-second decision. And this time it ended in tragedy.
Give you 31 minutes.
Thank you, Judge. And he fell. She didn't make a decision, I'm going to charge in there and start shooting people on the stage. He fell. And the physical evidence shows that she's telling the truth, because Ranger Adcock said, yeah, the casing's there. They're in the kitchen area. When we do our laser from where she says she was, that matches up to the second shot, probably, because of the recoil with one hand. And yes, this area, about 13 to 15 feet out front in that line, is about where he fell. And then she comes to the horrible realization when she came around that counter that she was in the wrong place and made a horrible mistake. That's what they have to prove beyond a reasonable doubt, that she didn't make a reasonable state of fact, or she didn't believe that was an intruder, or that she didn't exercise the apparent danger of believing there was a threat. They have the burden of proof to prove that beyond a reasonable doubt. What do they do that with? Josh Brown, nice kid. He was their ear witness that was out in the hallway. He was about to come around the corner, and what did he hear? He said he heard two distinct voices. He didn't know if they were man, woman, but two different voices, like talking at the same time. He can't understand what they're saying, but it was like they were like surprised with one another, like they came in on one another. That's the tone, and that's important. Like they're surprised at meeting one another. That's the tone he heard. He couldn't understand what they were saying. And they get him to say, well, you didn't hear any commands. Well, he can't understand what they're saying. He doesn't know what Amber Guyger is saying. Okay? But the tone's important, because what does it do? It matches exactly what Amber Guyger says. She's saying, let me see your hands, let me see your hands. Both saying, hey, hey, hey. Josh Brown corroborates Amber Guyger's story. He didn't go to proving beyond a reasonable doubt that she wasn't acting reasonably under mistake of fact, or beyond reasonable doubt that she wasn't exercising self-defense in what she mistakenly believed at that time. He corroborates exactly what went on. Then we have Miss Kinsey, who lived next door. She said, I've only heard people over in Bo's apartment one time. That's when he was watching the NBA Finals, and his back door was open and my back door was open. Otherwise, I can't hear this apartment. And she's talking on the phone, and she hears something. She thinks are shots. And then she says, I heard a man and woman kind of yelling. And then she remembers Amber Guyger out talking about giving out the number where she was. Could she have been mistaken? Which Josh Brown says the conversation happened before, right before the shot. She says right after. Doesn't mean both are lying or any one of them's lying. Could she be mistaken? Yes. Then you had Miss Hughes, who lived across the hall. She didn't hear anything beforehand, but she told you, no, I can't hear my neighbors in their apartments. She was watching TV doing her nails, and she heard two loud bangs. She doesn't help them prove their case beyond a reasonable doubt. Because self-defense has been raised, mistake of fact has been raised, and they have the burden to prove it. that they can't do it with those witnesses. The 911 call. Amber Guyger's on 911 in a panic. Prosecution wants you to believe that's some kind of interrogation, and because she didn't give those specific facts, somehow that means she wasn't in fear of her life because she didn't say I was shooting in self-defense. She's in absolute panic. She's not being interrogated and giving a statement. You can't rely on that at all. And finally, there's the bullet angle. They have said in their opening, and they keep saying that Botham Jean was on the couch, yet there's no evidence of that. I talked to the medical examiner about this. We could have the next slide. Amber Guyger said he was coming forward, and it was fired. And the medical examiner said, look, I said, is this possible? Because we have our angle, all right? If someone is coming forward and they see a weapon, is it possible they could duck? He said, yeah. Bodies are fluid. People, when they're frightened, move quickly. Someone's going to shoot at someone, they're going to try to avoid it. And that's how you get this angle. He says, all I can tell you is that's the trajectory of the bullet. How they were positioned could happen many different ways. But yes, he said, yes, that could very easily be the situation. So when he's coming forward, that's what you see. And it's so sad, really. It's so sad because obviously he had set the food down. Go to the next slide, please. Next one, please. Next one, please. You can see the bowl, but the spoon is pointed away. You can see the computer. He just set the bowl down. The lights are off. When he went home, he didn't know his door had left ajar, obviously. He didn't know that. He has ear pods in his ears. He can't hear. He's paused that TV. We know that. He paused it. He wasn't watching TV, probably to go fix his ice cream. And then he set it back down. He hadn't had a chance to unpause it. And then that door opens. And all he can see is a figure coming in. And why isn't he? Of course, he wants to know who's there. So he is saying, hey, hey, hey. And these two people have come into this situation, this tragic, tragic situation, and it's resulting in this horrible tragedy. It's like a horrible, perfect storm has come together, and this happened. Then we have the state's version of what may happen. They say, well, he was on the couch. There's no physical evidence showing he's on the couch. Yes, the bowl of ice cream is there. And if I could have the next slide, please. There it is. Look how the spoon is. It's not as if you're eating. We saw another photo of it's piled up. It's just been placed there. The cookies are still there. There's his computer, the TV. It's the game center. It's all on pause. Everything's on pause. And I said, okay, what would the angle be if he were sitting on the couch? Well, first of all, we went over painstakingly that if a person's going to get up off the couch, they may do it like this, depending on their physical, how they're built, how comfortable they are. Or, yes, you could have it. But if you're going to be shot in this position, you're going to be leaning over like this. Okay? That's how it would have to happen, as if you were getting up. Okay, if you're getting it shot in the heart, pierce your stomach, your lungs, is it reasonable to expect you might fall backwards on the couch at that point when you're hit by that round? There's no blood on that couch at all. We know that. The police looked. The DA's office was out there. No one saw blood. Is it reasonable, using your logic, that if you're in this position and you're getting up, leaning forward, and you're shot in the heart, you might fall forward, and if you fall forward, you're going to hit that computer, that ice cream, all those items. He's a 247-pound man, 6'1". That ottoman's right there at his knees. How did he avoid hitting that if he's shot in the heart getting up off the couch? And then, under their theory, he has to get up and walk about 7 feet towards the person that just shot him, then fall backwards. And we know where he hit because his ear pods popped out of his ears. And the only blood is right there. What's more reasonable? The Ranger Adcock said yes, he's about 13, 15 feet away, and he fell backwards after he shot. And I want you to take special notice of this because I know you're going to look at it. You see that little brown or reddish mark? I don't know if they're going to argue that's blood showing Botham Jean coming across, but we know it couldn't be. I asked the paramedic Farley, hey, when y'all came in there and exchanged the body, there was a body, put it on the stretcher, there was a lot of stuff going on. Could blood get transferred, get it flung about? Yeah. Next slide, please. No, the other way. We introduced this into evidence. That's from Officer Gwynn's body camera. Botham John is on the ground. He's being tended to by all these officers. But look, that area where you saw the red spot, nothing's there. The flashlight caught it. Nothing's there. So whatever was placed there later happened after he was shot and on the ground. Most likely when he was transferred up. But nothing's there. There's no physical evidence that puts him on the couch. And their scenario makes no sense. This is a sad, sad, sad case. We'll ask you to follow the law and the evidence. It's one of those cases that no one would ever think would exist. And it's one of those cases where there are no winners. A wonderful human being has lost his life, but the evidence shows it's just a tragedy, a horrible, horrible tragedy. Thank
you. You have 19 minutes. Thank you. May it please the court, members of the jury, defense, Amber, why are we here? The state will have you believe this is an out-of-control, unreasonable police officer that went on a murderous rage for no reason. That's what they're trying to show you. Why are we here? We're here because an awful tragedy occurred. An innocent young man lost his life. And a mistake was made that caused that. But what you are to consider is what the law is. And what they have to disprove beyond all reasonable doubt is whether the decisions that she made in entering that apartment and believing that it was her apartment and believing he was an intruder were so unreasonable. You must determine whether the state has proved beyond a reasonable doubt one of the following: the defendant's belief that she was entering her own apartment or her belief that the deceased was an intruder in her apartment was not reasonable. If you find that the state has failed to prove beyond a reasonable doubt either element 1 or element 2 listed above, you must find the defendant not guilty. That is the law. They don't like it. They are distancing themselves from the law. I think Mr. Fine called it garbage or trash or something like that. We're not here because whether they like the law or not. We're here because you are bound by the law. You are individuals that have sworn an oath that you are going to base your verdict solely on the law and the evidence. And the state has failed to prove anything. The state has failed to do their duty. We actually, even though we have no duty, we showed you how this was a reasonable mistake. The state, what did they bring you? Sexting and speculation. Everything that they have done has been to try to distract you and trick you from looking at the law in this case, because they know that if you apply it correctly, that Amber Guyger is not guilty. Sexting and speculation. But what it's about is Amber Guyger and how we got here. And is she an unreasonable person? Was it unreasonable for her to dream of being a police officer? Was it unreasonable for her to work full-time and go to college so she could put herself in that position? Was it unreasonable for her to join the Dallas Police Department and go through the academy and receive the training that teaches you how to use deadly force, to receive the training that teaches you that suspects' hands kill, that burglaries are inherently dangerous. And when you encounter a burglar, you go to your weapon. They had the opportunity to bring anybody from the academy to say that she acted counter to her training. Again, it's their burden. They have to prove that. They did not prove that. They brought you some standing operator procedures that we know do not apply. Because this was not a dispatch burglary call. This was not a barricaded person. This was not a situation where you have time to plan. Amber Guyger spent her life trying to do the right thing. She joined the South. She was moved to Southeast Patrol. She joined the CRT team. She interviewed and joined a team that has to be ready at any moment to respond to the needs of the different investigative units to help them detain and arrest the murderers and rapists and the robbers. Was that unreasonable on her part? Was it unreasonable for her to work hard? You have her work records that show in August there were several times she went to work at 5 in the morning. There's some days she worked 14 hours. Some days she's got lucky and only had to work 8 hours. And those are hours where your alert level goes up and down, as we saw on September 6th when she woke up at 5:30. When she got to work at around 7:45 and immediately started looking at intelligence reports because she wants to know what crime is afoot in her area, where the hot spots are. And she has to focus and pay attention, because if you don't understand where the violent criminals are, it could cost you your life. And so September 6th is a day full of ups and downs as far as alertness. They patrol regularly, looking at the different hotspots in the morning. Then they go to Central, and they have to have a debriefing with the SWAT team. And if you don't pay attention to that, because they're going after some armed and dangerous felons, if you don't pay attention, if you're not have a clear understanding what everybody's role is, then a mistake can be made, and you could lose your life. So there's all these different levels of alertness. They go to the scene. They're on the perimeter. They are watching SWAT's back. They are protecting SWAT so SWAT can get these dangerous, violent felons. Then they transport a dangerous, violent felon to headquarters. And then they have some downtime. But they're still responsible for these dangerous, violent felons, so they don't go all the way to zero. You know, when you're at a 7 or 8, when you're out on the perimeter, maybe you're down around a 4 or 5, but you're still aware. You're still working. They make it sound like the police headquarters is a day at the spa. No. They're abiding by their duties and their responsibilities. And then they have to take the same dangerous, violent suspect to jail and get him booked in properly in jail without any incidents. And then she goes back to the Southeast substation and docks her body camera, and she goes to zero. Keenan Blair told you, when you clock out, it's a different mindset. All that day of going up and down on alertness and everything else, she goes to zero. It's over. And she gets on the phone with Martin Rivera, and there is zero evidence. They brought you zero evidence that was anything other than a phone call. Martin Rivera got up here and told you what it was. He admitted to all the sexting. He admitted to the prior improper sexual relationship. So why would he have to lie about the contents of that phone call? They want to speculate. They want to anger you at these people that are having this improper relationship. But there is zero evidence that phone conversation was anything different than the other phone conversations that they've had. And she gets to her apartment, and she got lucky. And she went up in the parking garage, and she backed into that parking spot. And she saw the entrance. And she grabbed her 30-plus pounds of gear, and she walked straight in. And she didn't notice the skyline. Is that unreasonable? Is that criminal? Is that evil? Is that evidence of a murderous rage? And she walked down the hallway. So she had parked on the wrong floor, like nearly half the residents on the third and fourth floor have done. And she continued down the hallway towards the wrong apartment, like nearly half the residents on the third and fourth floor have done. And she got to the door, and she put her key in, like 1 out of 4 residents on the third and fourth floor have done. And everything started to happen in one motion. She heard the shuffling. She's putting the key in, and we know the key was the door was ajar. You heard from Special Agents Estes and Wallace about other people that they had interviewed where the door did the same thing. You heard from Texas Ranger Armstrong and saw the photos of the strike plate. You heard about the experiment that they did where the door did not shut all the way. You saw the video that shows the door is not shut all the way. Was that an unreasonable, evil circumstance created by Amber Guyger? The fact that there's no clear visual indicators on the parking garage walls, the fact that there's no numbers at eye level as you walk down these hallways of this apartment, the fact that there's no different color coding for each floor, is that Amber Guyger's unreasonable, evil action? And she gets to that door, and she obviously doesn't notice the red floor mat. Because what purpose? Why would she look at the red floor mat and say, you know what? I don't like this red floor mat. I'm going to go in and kill whoever's in here. Obviously, she didn't notice the red floor mat. And she put her key in, and it's all in one motion, and it pushes open. And my God, she's hearing these things, and she knows it's her apartment. She knows it's her apartment. And she goes from 0 up to 10 in a millisecond. Her heart rate starts to rapidly increase. Her heart rate starts to elevate. She starts to get that tunnel vision. And she's going to focus on what she perceives is an intruder. Because everything else doesn't matter. She knows she's in her apartment. The lights are off. All we have is the glow of the TV and the computer monitor. She doesn't have the benefit, like Mr. Hermes, of going through the photos with Robin Carr and pointing out every little distinct difference when all the lights in the apartment are on and she's using flash photography in those photos. Hey, look, he has a photo and she doesn't. She has a photo and he doesn't. Is that evidence she was unreasonable? That is ridiculous and absurd that they went through that. We went through hundreds of photos pointing out these differences that she obviously didn't see. She's focusing on an intruder in her apartment, and then the training kicks in, and she draws her weapon because she's taught that burglars are dangerous. And it's too late now. She's face to face. Keenan Blair told you. It's different. It's not a burglary call if you walk into your own home and are confronted with an intruder. It's different. You address the threat. Michael Lee told you it's different. You address the threat. Keenan, what do you focus on? Hands. Why? Hands kill. And it's dark in there, and she can't make out the hands. And poor Mr. John, he's got his AirPods in. He's smoked marijuana because we know it's in his system, and that's not relevant for any other reason than it might have added to the possible confusion and his ability to process this. He's not to blame for that. No one is. But he's trying to process this. And you look at those photos. They make it sound like he was sitting on the couch eating ice cream. The spoon is pointed away from the couch. When you're starting to eat a bowl of ice cream, the spoon is within where you're going to eat it. It shows, the physical evidence shows, he probably set down the ice cream and Amber Guyger comes into his apartment, and he's trying to process it. And all these circumstances have happened, and none of them are because she's unreasonable. None of them are because she's evil. It's because it's this storm that has come together, the perfect storm, and we know when she's standing in that apartment, she's done all these things all her life that she is reasonable. She's an ordinary and prudent person who made a mistake. She's an ordinary and prudent person who believed that this man who she's drawn a gun on, who keeps coming at her, who's saying, hey, 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 as she's saying, hands, let me see your hands, as Josh Brown corroborates, she believes this intruder is coming to kill her because he got caught and he's way back in the apartment and he's coming for her. And she fires her weapon. She fires it twice in quick, rapid succession like she's taught. And to that point, she's done everything like she's been trained to do and taught to do, and then she realizes what had happened. Now, the physical evidence is important because they have concocted a narrative that has zero support in the physical evidence. And that is so crucial. Because when you look at the evidence, when you look at Michael Lee's body cam, and you go to 5 minutes and 26 seconds in, you see the feet position of Mr. Jean. You see right there, no one's moved the body. They tried to make it sound like the body was being moved. The body was lifted up. The feet were lifted up, but this is before the feet were lifted up. You see Mr. John's feet. They're lined up with the frame of the bedroom. You see his right foot right next to a flip-flop and his left foot a little further out. So his body is facing the doorway. And so it's reasonable from the evidence and what Amber Guyger told you is that he's coming forward, and he's facing the doorway because the shot is straight on. The shot doesn't deviate either way. He's coming towards that doorway. Hey, who's in my apartment? And he sees the gun. The last thing she saw is this figure that's upright coming at her, and he gets shot. And that's consistent with the angle. And that's consistent with him falling right here because he had a rapidly fatal wound. It is pure conjecture. It is pure speculation to try and say that he would have taken two purposeful steps. That is out of the imagination of the state of Texas.
Yeah, 3 minutes.
Thank you, Judge. You have the AirPods that you can see are just lying right next to Mr. John's ear. I find it hard to believe and hard to fathom if he was somehow getting up off the couch that he would have perfectly navigated the ottoman, walked towards the person that just shot him. So for some reason, he's been shot. He's walking perfectly in a straight line towards the person that just shot him. The AirPods are still in his ears and somehow stops and falls back. That is preposterous. That is the conjecture that the judge has told you not to engage in. The investigation by the Texas Rangers. So the Texas Rangers come in. The Texas Rangers, one of the most elite investigative units in the country. And Ranger Armstrong told you what he did. Because he wanted to know, his focal point was her coming to that apartment reasonable? And every step he took of the investigation and everything he did showed that it was. The canvas, was that significant, Ranger Armstrong? Oh yes, it was significant. The door, well yes, it does. It corroborates Amber once again. The parking garages, the layout of the apartment complex. The physical evidence corroborates what Amber Guyger told you. The state of Texas cannot bring you one shred of evidence, anything that shows that she was unreasonable. The state of Texas cannot bring you one shred of evidence to support their absurd hypothesis about him sitting on the couch. Ladies and gentlemen, thank you. Thank you for your time. Thank you for letting us take you away from your families. This case is a case that depends upon you to look at the law and look in the evidence. And it's clear. If you find the state has failed to prove that she was unreasonable, if you find the state has failed to prove that she was unreasonable in her belief that Mr. John was in her apartment and that he was an intruder, you must find Amber Guyger not guilty. Every single one of you has the power to say not guilty. If the state did not prove this case beyond a reasonable doubt, if a single reasonable doubt remains, each and every one of you has the right and the responsibility and the duty and the courage to say not guilty. Ladies and gentlemen of the jury, the evidence is clear. We've proved it. They certainly have failed to disprove it. That Amber Guyger firmly believed, reasonably, that she was in her own apartment. That Amber Guyger firmly believed in those seconds that she was facing an intruder. The law is clear. Your duty is clear. Find Amber Guyger not guilty. Thank you.